of an occupying power to ensure that the population is adequately supplied. The occupying power may never invoke reasons of security to justify the general suspension of all humanitarian activities in occupied territory. The Court observes that the distribution of humanitarian relief in an impartial manner requires considerable planning and coordination. Thus, an occupying power must do more than simply allow the passage of essential items into the occupied territory. It must also use all means at its disposal so that these items are distributed in a regular, fair, and non-discriminatory manner, including by facilitating access to them and refraining from threats or use of violence or lethal force against the civilian population seeking to access such humanitarian relief. Relief schemes must be carried out in a manner that respects the dignity of the local population and that is consistent with the protection of the human rights of that population. The obligations contained in Article 59 of the Fourth Geneva Convention arises only when the whole or part of the population of an occupied territory is inadequately supplied. After examining the evidence, the Court finds that the local population in Gaza Strip has been inadequately supplied within the meaning of Article 59 of the Fourth Geneva Convention. In such a situation, Israel, as an occupying power, is under an obligation to agree to and facilitate relief schemes under that provision. The Court next considers Israel's obligations under Article 59 as they relate to UNRWA. The Court observes that these obligations also apply to relief schemes provided by United Nations entities more broadly. The same is true, in principle, for other humanitarian organizations seeking to provide humanitarian relief in the Gaza Strip. The Court recalls that Israel does not consider UNRWA to be an impartial organization and has argued that, as a result, UNRWA does not come within the purview of Article 59. The Court observes that the qualification of a humanitarian organization as impartial or otherwise must be based on an objective assessment. It cannot depend only on the unilateral claim of the organization in question or on the unilateral perception of the occupying power. The Court notes that based on the case file, there is no evidence that UNRWA as an entity breached the principle of impartiality within the meaning of Article 59. In other words, there is no evidence that UNRWA has discriminated with respect to nationality, race, religious belief, class, or political opinion during its distribution of humanitarian aid and provision of services in the occupied Palestinian territory. The Court observes that while neutrality is not a separate requirement under Article 59, the two concepts are related, and neutrality plays a role in assessing the impartiality of the activities of humanitarian organizations. Israel alleged that UNRWA has been infiltrated by Hamas and other terrorist organizations, and that UNRWA employees took an active part in carrying out the attacks of 7 October 2023. Israel further alleged a widespread and systemic misuse of UNRWA's assets and facilities by Hamas. According to Israel, its concerns were not adequately addressed by the United Nations. The Court considers that the information before it is not sufficient to establish UNRWA's lack of neutrality for the purpose of assessing its impartiality as an organization under Article 59. In particular, the fact that the OIOS investigation in 2024 led to the dismissal of 9 members of UNRWA personnel due to their possible involvement in the 7 October 2023 Hamas-led attacks against Israel is insufficient to support a conclusion that UNRWA as a whole is not a neutral organization. In addition, the Court finds that Israel has not substantiated its allegations that a significant part of UNRWA employees are members of Hamas or other terrorist factions. The Court notes that an occupying power is in principle free to choose the humanitarian organizations through which it fulfills its obligation to agree to and facilitate humanitarian relief. However, Article 59 limits an occupying power's discretion insofar as it requires that power to allow and facilitate sufficient relief to ensure that the population is adequately supplied. The Court recalls that UNRWA has become the lead United Nations agency for relief and assistance to Palestine refugees in the occupied Palestinian territory and neighboring states, playing a critical role in the Gaza Strip. UNRWA has thus been deeply integrated into the local infrastructure of the occupied Palestinian territory, providing for the most basic needs of the local population, including food, potable water, healthcare, and shelter. The Court recalls the scale and urgency of the needs of the population of the Gaza Strip and UNRWA's unique and sustained connection with the population of the occupied Palestinian territory. The Court considers that in the current circumstances, it is not possible to replicate the capacity of the United Nations acting through UNRWA to ensure that the population of the Gaza Strip is adequately provided for. UNRWA cannot be replaced on short notice and without a proper transition plan. The Court further observes that Israel itself has not ensured that the population of the Gaza Strip is adequately supplied. The Court recalls that in addition to severely restricting the entry of aid at various times after 7 October 2023, Israel blocked the delivery of humanitarian aid in the Gaza Strip starting from 2 March 2025 and only allowed the delivery of a limited amount of aid to resume on 19 May 2025. The evidence thus shows that whether or not the operations of the United Nations acting through UNRWA were replaceable, Israel had no replacement system mobilized for a 10-week period. The Gaza Humanitarian Foundation, a purported replacement for UNRWA, has been widely criticized by the United Nations and other international actors, and its operations have been alleged to be inconsistent with core humanitarian principles. The United Nations observed in its response of 27 August 2025 that aid delivery remains significantly below the volume required to meet the needs of the population. According to the Office for the Coordination of Humanitarian Affairs of the United Nations, to which I shall refer as OCHA, over 2,100 Palestinians have been killed at or near the distribution sites of the Gaza Humanitarian Foundation since that system began operating on 27 May 2025. The Court concludes that in the present circumstances, the United Nations, acting through UNRWA, has been an indispensable provider of humanitarian relief in the Gaza Strip. Having regard to Article 59 of the Fourth Geneva Convention, and in the circumstances, the Court considers that Israel is under an obligation to agree to and facilitate relief schemes provided by the United Nations and its entities, including UNRWA. The Court adds that Article 59 of the Fourth Geneva Convention refers to aid provided by states or by impartial humanitarian organizations. Thus, as long as the population remains inadequately supplied and Israel is not itself operating a system of humanitarian support,